Judge mocks teen in court, then realizes he's facing a genius in disguise. Imagine walking into a courtroom as a teenager, alone, unrepresented, and accused of grand theft auto. The judge smirks, the prosecutor grins, and the entire room is ready to dismiss you before the trial even begins. But then, you open your mouth, and everything changes. This is the story of how one 19-year-old didn't just survive a courtroom battle. He outmaneuvered a professional prosecutor, shocked a judge, and exposed cracks in a system that too often rushes to judgment. But let's be clear, this isn't just courtroom drama. It's a mirror to the justice system, a cautionary tale, and a call to action. Because for every Jalen Dawson who knows how to fight back, there are countless others who don't. And today we're going to unpack why this case was never really about guilt or innocence, but about power, perception, and the underestimated brilliance of a young man who refused to be just another statistic. Los Angeles County Courthouse, 2 p.m., and already the air is thick with anticipation. But it's not excitement, it's expectation. The kind that settles over a courtroom when everyone assumes they already know how the story ends. The defendant, Jalen Dawson, 19 years old, charged with grand theft auto and resisting arrest. But if you look beyond the charges, you'd see something the judge didn't, not right away. A calm stare, an upright posture, and a silence that didn't come from fear, but from calculation. Judge Walter Grayson, however, wasn't looking for complexity. He leaned back, smirked over his glasses, and fired the first shot. This isn't debate club, kid. Let's pause here, because this is the moment that defines everything that follows. That smirk, that tone, it's not just a power play, it's a reflection of a justice system where bias doesn't always wear a hood. Sometimes it wears a robe. Statistically, young black men are more likely to face harsher judgment, less benefit of the doubt, and more wrongful accusations than nearly any other demographic. According to the National Registry of Exonerations, black defendants are 7 times more likely to be wrongfully convicted of serious crimes than white defendants. That reality is woven into the smirk Judge Grayson gave Jalen before a single word of testimony was heard. But Jalen? He wasn't there to play the victim. He was there to flip the script. The courtroom settled into a rhythm, at least on the surface. The judge leaned back, clearly uninterested. The bailiff yawned. The stenographer kept typing like this was just another Tuesday. And then came the performance. Mitchell Carrington, the prosecutor, stood with the posture of a man already tasting victory. Tailored suit, confident voice, and a rehearsed speech that felt more like a formality than a pursuit of justice. The state will prove beyond a shadow of a doubt that the defendant, Jalen Dawson, was caught red-handed in a stolen vehicle, a 2022 Audi A6. Sounds airtight, right? A stolen luxury car, a teenage suspect, fingerprints on the steering wheel, a chase, an arrest. You could practically hear the gavel falling already. But here's the thing about courtroom theatrics. Confidence often hides weak foundations. And Carrington, he was building on sand. Let's pause to break this down. In many courtrooms across the country, prosecutors rely heavily on perception. A young black man, a stolen vehicle, and a police report, that's more than enough to sway a jury, especially if the defense stays quiet. But what Carrington didn't anticipate was that Jalen wasn't there to play defense. He was ready to interrogate the truth. What kind of victim runs from the police? Carrington's words weren't just rhetoric. They were weaponized assumptions. They hinge on a flawed but persistent narrative. If someone flees, they must be guilty. But the truth? People run for all kinds of reasons: fear, confusion, distrust of the police. A 2021 study from the Vera Institute found that many young men of color flee even when they've done nothing wrong, simply because they feel unsafe during police interactions. That reality never makes it into courtrooms where the script is already written. But back to Jalen. He watched, listened, waited, because he knew Carrington's case wasn't as bulletproof as it looked. And then came the moment. "Your Honor," Jalen said calmly, "I'll be representing myself." The room froze. The smirks vanished. This teenager wasn't going to play the role they assigned him. He wasn't scared. He wasn't scrambling. He was standing. And he knew something they didn't, how weak their case really was. Now let's be real. Self-representation is risky. Legal experts often advise against it, and for good reason. Navigating courtroom rules, evidentiary procedures, and cross-examinations takes years of training. But Jalen wasn't just any teenager. From the age of 12, he'd been reading legal textbooks like others read comic books. While his peers practiced slam dunks and cheat codes, he practiced objections and legal strategy. His mother, a paralegal, had raised him in the world of case law, procedural nuance, and late-night breakdowns of legal drama. So when Jalen stood and took control of his defense, it wasn't arrogance, it was preparation. "I'd like to verify Officer Ruiz's GPS logs from that night," he said. A simple request, but it landed like a thunderclap. Why? Because the officer whose testimony was central to the prosecution's story, claiming he saw Jalen behind the wheel, might not have even been on duty when the alleged crime occurred. This is where the real trial began. You see, trials often hinge on credibility, witnesses, testimony, trust. But if that trust is broken, if an officer's story doesn't match the data, then everything else begins to crumble. And here's something the average person might not know. Police GPS logs are discoverable evidence. That means defense attorneys, or in this case, defendants, can request them to verify officer locations. If the logs don't match the testimony, that's called impeachment material, and it's deadly to a case built on assumptions. Carrington hesitated. A small pause, barely noticeable. But in that silence, the tide shifted. And Jalen, he didn't miss a beat. If the officer was where he claimed to be, the GPS logs will prove it. But if he wasn't, he let it hang. That moment changed everything. Let's reflect for a second. Jalen didn't just poke a hole in the prosecution's narrative. He did something most defense teams struggle to do: create doubt in the reliability of law enforcement testimony. That's no small feat. Statistically, juries tend to favor police testimony. A 2022 Pew Research study found that more than 60% of jurors begin a trial with an implicit bias in favor of law enforcement accounts. But Jalen knew that data could override instinct. He didn't just argue, he demanded evidence. And this is where the real brilliance comes in. While the courtroom was still processing this twist, Carrington tried to pivot. "Your Honor, the defendant's fingerprints were found on the steering wheel." Another classic move. When one pillar starts to fall, shift the weight to another. But Jalen wasn't finished. He didn't argue the fingerprints. He acknowledged them and then reframed them. Does touching something make you a criminal? It's a deceptively simple question, but it reframed the entire trial. It forced the jury and the judge to rethink what they thought they knew. Imagine this. You lean on a car for a second. The car gets stolen hours later. Your prints are there. Should that alone be enough to convict you? Jalen used analogy, something every great attorney does. He compared the situation to trying on a jacket in a store. Your prints might be there, but that doesn't mean you stole it. It means you touched it. And in that comparison, Jalen achieved what most attorneys strive for in opening arguments. He planted reasonable doubt. Because in criminal court, the burden of proof isn't 70% or even 90%. It's beyond a reasonable doubt. That's the standard. And by reframing the evidence, Jalen didn't just defend himself, he redefined the narrative. There's a moment in every courtroom drama where the audience realizes this isn't going to end the way they expected. That moment came halfway through day 3. Jalen Dawson, still representing himself, stood quietly at the defense table. No legal team behind him, no family beside him, just a stack of hand-marked documents, a half-empty notepad, and the weight of the state pressing down on him. But in his silence, there was strategy. Prosecutor Mitchell Carrington wasn't silent. He'd returned to the podium with renewed focus, leaning hard on his remaining evidence, the forensic report. It was his last clean card in a deck that was showing cracks. We have fingerprints, no glove traces, no smudges, full impressions. Steering wheel, driver's side door handle, gear shift, all consistent with operation of the vehicle. The jury nodded. It sounded clinical, objective. Science, not speculation. But the best courtroom manipulators know. Forensics are only as strong as the questions they're not asked. And Jalen? He asked every question. He approached the bench for cross-examination like a seasoned litigator. Calm, measured, but with a quiet intensity that made even the bailiff sit up. "Ms. Benton," he began, addressing the forensic tech, "can you confirm the timestamp of when these fingerprints were lifted?" She flipped through her notes. "Approximately 10:48 a.m., the morning after the vehicle was recovered." Jalen nodded. "And can you confirm whether the vehicle had been handled by any officers or civilians prior to that time?" A pause, then, I can't say definitively. That's not within my scope." "So it's possible other individuals touched the vehicle before the prints were recovered?" "Yes." "Including officers who weren't wearing gloves?" "It's possible, yes." And just like that, the forensic evidence, Carrington's holy grail, was contaminated. This wasn't speculation. This was policy failure. Let's break this down for a moment. In any criminal investigation, the chain of custody is critical. It's the documented and unbroken trail of evidence from the moment it's discovered to the moment it's presented in court. If there's a break or if it's unclear who handled the evidence and when, the integrity is compromised. According to a 2022 Department of Justice procedural audit, nearly 27% of felony convictions that were later overturned involved mishandled or unverified forensic evidence. And that's not just junk science cases. It includes fingerprint evidence tainted by poor collection practices, improper storage, or careless contamination. Jalen knew this, and more importantly, he made sure the jury knew it. He stepped away from the podium. "Ladies and gentlemen," he said, turning to the jury, "if you found a fingerprint on your steering wheel, would you assume that person stole your car? Or just that they'd touched it?" The silence that followed wasn't uncertainty, it was realization, a mental shift. The story was no longer about a stolen Audi. It was about something much bigger, how easy it is for the system to label someone a criminal without checking the facts. But Jalen wasn't done. Next came the surveillance footage. Carrington had introduced it on day 2, a grainy security clip from a nearby liquor store. It showed a figure getting into the Audi the night it was reported stolen. The person wore a hoodie, head down, features unclear. Carrington claimed it reasonably resembled the defendant. A typical phrase, not confirmation, just suggestion. But Jalen had done his homework. He subpoenaed the rest of the footage, not the 30-second clip, the full 2 hours. And in that extended footage, never shown by the prosecution, came the moment everything turned. There, timestamped just 4 minutes after the car was stolen, was the same figure seen in the clip, standing on the corner of Crenshaw and 8th in a completely different outfit, entering a convenience store. "Your Honor," Jalen said, "I move to admit this full video into evidence under Rule 106, the rule of completeness." Legal audiences would have clapped. Rule 106 requires that when part of a recorded statement is introduced, the rest must be shown if it's necessary to understand the context. It prevents cherry picking, exactly what Carrington had done. And the judge, who'd seemed half asleep since jury selection, finally leaned forward. "Objection?" the judge asked Carrington. "No objection," the prosecutor muttered. The footage was played. The jury leaned in. And the man they were told was clearly Jalen was now visibly taller, with broader shoulders, a beard, and a limp. It wasn't him. And suddenly, everything shifted. Let's pause here. This is what courtroom turning points look like. Not dramatic confessions or teary breakdowns, but cold, factual reversals. The kind that suck the oxygen out of the room. Because they don't just question the evidence, they dismantle it. Jalen had now done 3 things. 1. Discredited the eyewitness officer via GPS and dispatch logs. 2. Weakened the forensic case by exposing procedural failures. 3. Undermined the prosecution's video evidence with complete footage. 3 pillars. All cracked, all falling. By this point, whispers had started in the gallery. The jurors were exchanging glances. And Carrington? His confidence was unraveling. In a desperate move, he pivoted to motive. "Your Honor," he began during redirect, "the defendant had no explanation for being near the scene of the crime." But Jalen was ready. That's because I wasn't near it. I was across town, at home, playing Xbox, and my online login timestamps matched the time of the alleged theft. He pulled out a screenshot of his gaming profile, logged into a PS5 at 10:42 p.m., the exact moment the car was taken. Location data embedded. Wi-Fi IP address traceable. Suddenly, the idea that this was just a misunderstood teen fell away. This was a wrongfully accused teen, one who had receipts. Every trial has a rhythm, a heartbeat. Some beat slow and steady, a march toward the inevitable. Others, like the State versus Jalen Dawson, pound like war drums, every revelation a jolt of electricity. By the morning of day 4, the court gallery was packed. Local news reporters filled the back row. A few law students stood pressed against the wall, scribbling notes. And near the front, Jalen's mother finally appeared, eyes swollen, hands clutched in prayer. She hadn't come before, not because she didn't care, but because she couldn't bear to watch her son fight alone. And yet, he hadn't been alone. He had facts, he had strategy, and most of all, he had truth. Now it was time for closing arguments. The prosecutor rose first. His suit looked more wrinkled than usual. His voice, once dominant, now tinged with caution. "Ladies and gentlemen," he began, "this case is about accountability. A luxury car was stolen. It was found blocks from the defendant's home. His fingerprints were on it. Surveillance places him near the scene. You've seen the facts. But the facts no longer stood uncontested, and even Carrington knew it. There may be questions, yes. There may be gaps. But in criminal court, we don't need perfection. Just proof beyond a reasonable doubt." It was a technical close, a defensive one, not the soaring rhetoric prosecutors rely on when their case is airtight. It was a hedge, an exit ramp, in case the jury turned against him. He sat down with a sigh. Then Jalen stood. He didn't move to the podium. He stayed where he was, hands flat on the defense table, eyes locked on the jury. They want you to believe this is just about fingerprints and shadows and video, but it's not. It's about what happens when the system sees a young black man walking at night and decides he must be guilty. He paused. "I didn't ask to be my own lawyer. I didn't go to law school, but I did pay attention. I read every file, watched every minute of video, compared every timestamp. Not because I wanted to prove a point, but because I had to, because no one else was going to fight for me." Jalen's voice didn't shake, but the courtroom did. This isn't just a trial, it's a test of whether facts matter, of whether innocence matters, and of whether any of you can look at me after everything you've seen and say, "Yeah, we're sure he did it." He stepped back, sat down, and for the first time all week, rested. There was nothing left to say. The jury was gone for 6 hours. Every tick of the clock stretched time like elastic. Jalen stared at the wood grain on the table. Carrington paced like a man trying to outrun his own doubts. The bailiff shuffled between the jury room and the judge's chambers with nothing to report. And finally, at 6:14 p.m., the buzzer rang. The jurors filed back in. The foreperson, a woman in her 50s with steely eyes and a calm voice, held the verdict slip. "Madam Foreperson," the judge asked, "has the jury reached a verdict?" "We have, Your Honor." The courtroom air went still. "On the charge of grand theft auto, how do you find the defendant?" A beat. Not guilty. A gasp. Not from Jalen. He just exhaled. But from the gallery. From Carrington. From everyone who thought this would be just another name, just another number, just another kid steamrolled by the system. But not today. Not Jalen Dawson. The judge banged the gavel. The trial was over, but the story wasn't. Outside the courthouse, reporters clamored for interviews. Jalen gave none. He hugged his mother. He shook hands with the court clerk. Then he walked home. The DA's office later released a statement calling the case a disappointment. But privately, sources confirmed Carrington would not be assigned to high-profile trials again for the foreseeable future. More importantly, the case became a minor legend in legal circles. Taught in ethics seminars and public defender boot camps as a case study in how evidence, bias, and perseverance collide in American courtrooms. In time, Jalen would go on to study criminal law, not out of vengeance, but purpose, because once you survive the system, you understand it differently, not just how it works, but how it fails and how to make it better. This story wasn't fiction, not really, because every courtroom in America has seen its own version of Jalen Dawson, a defendant presumed guilty based on proximity, appearance, or past assumptions. A prosecutor more committed to conviction than truth. A jury forced to choose between what's likely and what's just. But Jalen reminds us, truth needs defenders. And sometimes they wear no badge, hold no degree, carry no briefcase. Sometimes they're the ones accused.